I'm Carl Vincent, Head of Employment at Girlings, and I'm going to answer a few questions shortly on settlement agreements. A settlement agreement is a written document normally made between an employer and an employee which deals with the employee's exit from their employment. It normally provides for payments to the employee and a waiver of claims in favour of the employer. It gives an employer a clean break, so the reassurance that once the agreement is made, it's not going to receive any employment claims afterwards. Well, the alternative to signing a settlement agreement is chancing your arm in the Employment Tribunal, but that's risky because it takes time, it costs a lot of money, and of course you've got to win. And even if you get a tribunal decision in your favour, the Employment Tribunal doesn't have the power to order certain things like an employment reference, for example. An employee can't be forced to enter into a settlement agreement by his or her employer. At the end of the day, it's a consensual process, and if the employee doesn't want to sign, the employer can't insist. You need a solicitor to act for you when you're signing a settlement agreement because a settlement agreement is not enforceable until you've received advice from a solicitor on the effect of signing it before you sign. Settlement agreements are always negotiable in the sense that whatever's offered by the employer, it's up to the employee to consider it and either accept or come back with a counter offer. Whether or not the offer is adequate will depend upon a number of things: what the employee's contractual rights are, whether they have any particular employment claims they could bring, and whether there are any other sort of factors in the background that can be leveraged. The payments you'd see in a settlement agreement, they normally fall into two camps. There'd normally be a set of payments which reflect the employee's contractual entitlements, such as pay to the termination date, holiday pay, pay in lieu of notice, and then normally there's a consideration for signing the settlement agreement, which normally takes the form of an ex gratia payment or a compensation payment to the employee. You see lots of non-financial terms in settlement agreements. They vary a lot depending on the context, but the things you typically see are provisions governing confidentiality, mutual non-disparagement provisions, provisions giving the employee the right to receive a reference. Sometimes ancillary benefits are covered, such as outplacement or porting of mobile number and the gift of IT equipment. And tax indemnities. Often an employer will take the opportunity of a settlement agreement to reaffirm any post-termination restrictions which appear in the employment contract. Post-termination restrictions may be seen in a settlement agreement. They're normally in the employment contract originally, and they are terms in an employment contract which control, normally for a limited period, what the employee can do after employment's terminated. So they govern things like whether the employee can go and work for a competitor, the extent to which the employee can approach the employer's clients, the extent to which, if the employer's clients reach out to the employee, whether or not the employee can do business with them. And typically there are also controls on the ability of the employee to try and persuade their former colleagues to leave and join them wherever they are. A non-compete provision is a provision typically seen in an employment contract which prevents the employee from leaving the employer and, for a defined period, going to work for a competitor. And the principal function of those clauses is typically either the protection of the employer's confidential information or the goodwill of its business. I think before an employee signs a settlement agreement, they need to take a step back and make sure that they're comfortable that they're leaving on the date specified in the agreement, and that the payments that they're receiving adequately reflect both their contractual entitlements and their potential claims on exit, so that they're not selling their rights too cheaply. So you commonly see in settlement agreements provisions which are mutual, which prevent either party disparaging the other post the end of the employment relationship. And in addition, it's very common for the employer to give the employee a reference in an agreed form, which is normally appended to the document itself. That can't be a complete bind on the employer because it has legal obligations to the potential recipient. So there are normally provisions in the reference clause which give the employer some wiggle room. The two questions I'm most often asked in the context of settlement agreements are, what's it going to cost me? and how much tax do I have to pay? And the answer to both is it depends. How much it's going to cost depends on how complex the situation is and how much of how tough the negotiation is and how contentious the situation is. How much tax you have to pay is more technical, and it depends on the sort of payments that are covered by the settlement agreement and whether or not we can do anything to make the package as a whole more tax efficient by allocating payments in certain pots. For example, payments made by the employer under a settlement agreement directly into a pension plan can be paid without deductions. If you have any questions or queries in relation to settlement agreements, if you need a settlement agreement drafted or looked at, then you shouldn't hesitate to get in touch with one of the team here at Girlings in Ashford.